Hank. Thank you.
Thank you, Chairman Nadler, and thank you for your leadership on this issue, Senator Markey, Representative Jones. I'm Congressman Hank Johnson, and I have the privilege of chairing the House Judiciary Committee Subcommittee on Courts, Intellectual Property, and the Internet. As a criminal defense lawyer for 27 years and a magistrate court judge for 12 of those years, prior to coming to Congress, 27 years as a criminal defense lawyer, I have a great deal of respect for the judicial branch, the third co-equal branch of government, and the independence of the court is critical. Most folks assume that the Constitution mandates the number of justices on the Supreme Court must be 9, but nowhere in the Constitution is it written just how many justices should sit on the Supreme Court. I would submit that the reason why the framers did not enumerate how large the court should be is because they envisioned that the legislative branch would need to have flexibility in tending to the court's operations from time to time. So the Constitution does not require that there be 9 justices sitting on the Supreme Court. The fact is that Congress has changed the size of the Supreme Court 7 times over the course of the nation's history. The first time, in fact, only 13 years after the Constitution was ratified, when the presidency and Congress were still governed by our country's founding generation. The real outlier is the fact that the court hasn't changed while the rest of the federal government has grown, keeping pace with the growth of the nation. Many of the earlier changes in the number of justices were made specifically in response to national growth. In 1807, for example, a Seventh Circuit Court of Appeals was added when Kentucky, Tennessee, and Ohio were added to the Union, and a new justice was added to the Supreme Court, bringing the total number of justices to 7. But this natural expansion stopped after the Civil War, leaving us today with the historical oddity of 13 circuit courts of appeal and only 9 justices. I believe it's time to go back to this tradition and have at least 13 justices. With 13 justices, each justice would be able to have responsibility for emergency applications for a single circuit instead of the current status quo where 1 justice covers 3 circuits, 2 justices cover 2, and the remaining 6 justices cover 1. We recently held a hearing on this docket, what some have called the Supreme Court's shadow docket, because of the court's recent tendency to issue orders on that docket that have enormous impact, but which, in stark contrast to normal practice, might not be accompanied by an opinion explaining the court's reasoning, even if some justices dissent. I'm hopeful that by spreading this work out among more justices, there will be more capacity to appropriately deal with emergencies, including explaining the court's reasoning in important cases. Bringing transparency and light to this increasingly important part of the Supreme Court's practice is necessary. I'm also hopeful that additional justices will allow the Supreme Court to hear more cases in a given term. There is an enormous disparity in the number of cases heard by the courts of appeals and the Supreme Court. In 2019, the courts of appeals decided more than 50,000 appeals. In contrast, the Supreme Court has decided fewer than 100 cases in recent terms. In 100 cases decided as a percentage of 50,000 cases dealt with by the courts of appeals is a paltry 0.02%. This disparity means that getting a case in front of the Supreme Court starts to resemble winning the lottery for anyone without connections. This scarcity has led to a cottage industry where litigants who can afford to do so spend enormous time and enormous energy and enormous money in rallying others to file friend of court briefs, amicus briefs, to urge the Supreme Court to agree to hear a case. I have serious concerns, ladies and gentlemen, about whether a two-tiered justice system has developed, one reserved for marquee cases, white shoe lawyers, and wealthy litigants, and one for everyone else. In sum, it's time that we start thinking about the Supreme Court like we think about the rest of the federal government and consider whether and how its current composition allows it to effectively do what we need it to do, which is to efficiently and effectively administer justice and uphold the rule of law. I'm pleased to join my colleagues, Senator Markey, Chairman Nadler, and Representative Jones in taking an important step in that direction today with the introduction of the Judiciary Act of 2021, which I'm proud to sponsor. And now I'm happy to turn the podium over to my colleague and Vice Chair of the Subcommittee on Courts, Intellectual Property, and the Internet, Representative Mondaire Jones from New York.